Okay, so this morning we're going to be talking about our last part for the elements of a contract. And the last part is called intent, which is a very important part of the contract. First of all, there has to be a meeting of the minds. I remember talking earlier in the semester to you guys about the idea of capacity, or the ability to understand what one is signing. Both people, when they're signing a contract, have to understand what's going on. It has to be like a meeting of the minds. But there are several aspects that can impact the meeting of the minds: capacity, misrepresentation or undue influence, duress, a mistake, illegality, the Universal Commercial Code, Uniform Commercial Code, and the Statute of Frauds and peril evidence are all factors that can impact this idea of intent. So let's start with capacity. A couple of different aspects about capacity that can really impact whether or not a contract is enforceable. One is, does the person understand what they're reading? Normally, minors, for example, anybody under the age of 18, are not considered able to sign a contract and have that contract enforceable. Also, somebody who might have a diminished capacity, meaning maybe they have either a disability or their mental capacity has been diminished in some form or fashion via illegal drugs or drug use in general, or alcohol. And finally, corporations do not have capacity. It's one of the reasons why there has to be a power of attorney or someone that represents a corporation, but a corporation itself does not have capacity to have an enforceable contract. So I'm going to go through several of these slides here. You can take a look at them. They are on Canvas for you. And let's talk a little bit about misrepresentation or duress. That's another area in which one can make that can change a contract. You can't force someone to sign a contract. You can't coerce them, or you can't bribe them. These would all make a contract unenforceable. Okay, a mistake can make a contract unenforceable, where someone can either have a bilateral mistake where both parties misunderstood what's happening, and you start reading the contract, wait, this is what we expected, so obviously you wouldn't sign that contract, that would be nullified. Or a unilateral mistake where one party only makes a mistake. Now, oftentimes unilateral mistakes can be still enforceable unless the person who the person who had the misunderstanding, it doesn't really matter if they had the understanding unless the other party knows the person understood and still is trying to get them to sign it. So anyway, illegality, obviously, waivers in some states could be not legal if a state doesn't utilize waivers. Some states would enforce waivers, others won't. And if you're in a state that doesn't enforce a waiver, well, that contract is unenforceable. It's null. Or if somebody committed a crime and then signed a contract, and they may not have legal standing. Could be covenants to not compete in the sport world, where, say, a student athlete is signing for a school that had played in the same conference, but that conference has a non-compete clause within their legislative body, and that student doesn't know that or understand it, and neither does the coach. Well, that contract would be null and void. Or inciting somebody to break a contract. Most contracts are oral contracts are legal. However, if a contract isn't going to be able to be performed within the year, usually it has to be in writing. So statute of frauds have certain rules in place. So if you're selling land or doing a lease, there has to be a written contract. Any agreement in which can't be performed within 1 year needs to be a written contract. And anything that has sale of goods exceeding $500, there has to be a contract. All right. Peril evidence is basically when someone says, oh, but wait, we talked about this, and they might even have a recording of it, or they might have some written form, some notes that they wrote down from a conversation. Courts usually don't allow external evidence like this when it comes to contract disputes. Courts will view the contract itself as binding, and when you sign a contract, hopefully you've read it, and as a result of reading it, there shouldn't be any misunderstanding or other extraneous material that's not in the contract itself. So that's why where parallel evidence is usually not allowed. Unless the contract itself is ambiguous and not very clear, then they might use evidence that's outside the contract to try and clear up the matter. All right, remedies for breach of contract. Well, you just rescind it or not use it, or there can be damages given, and or in case of like sport memorabilia, they might force you to hand that over because those often have no monetary value. They're of special value. Okay, I'm going to move on here real quick through these. You guys can take a look more closely at what the slides say. All right, employment contracts I want to get into. Employment contracts often will list the duties of what the employer and employee are expected. There's usually a term of service. There are other clauses like rollover provisions, reassignment clauses. Say let's say somebody gets hurt and they no longer can perform some certain duties, but then they can be moved to another position within the company or organization and still perform and still execute some certain expectations and still stay on the payroll. Could be a reassignment clause. There are compensation clauses oftentimes that may be graduated or different depending on certain degrees or expertise learned. You might jump to another category. Provisions for outside or supplemental income. Some companies won't let you work outside your company. They want all of your devotion towards the company. Termination clauses. Some contracts might have a termination clause where you get compensated regardless once you're terminated, or buyout provisions where someone can pay money again to buy out your services, or arbitration agreements suggesting that if there is a dispute about your employment contract, you've agreed to settle out of court. So again, you guys can take a look at these slides a little closer on your own. One slide I do want you to take a look at is the independent contractor versus employee. This is an Internal Revenue Service checklist that goes in, very detailed checklist as to what it means to be an employee, and it's very important if you're ever working for a club that you know whether or not you're considered an independent contractor or an employee, not only for liability reasons but also for tax reasons. Okay. Next is letter of intent, or in the NCAA they have an organization called the NLI, or the National Letter of Intent. It's its own body and it kind of governs itself. You guys can take a little closer look at this. I'm not going to walk through it too much, all right? But and then game contracts. Game contracts are important in the sport business, no matter what level you're at, in part because they specify who, what, where, and when, and what kind of payment expectations there are. So could be also talk about what the role, who's paying for officials, what rules the organization is going to be abiding by. So for example, the NAI abides by the NCAA playing rules for women's soccer, for example. Television rights and radio rights and media rights, if there are any, or complimentary ticketing. Could be also travel and expenses. Oftentimes, if a team is traveling at far distance, the host team may provide housing or may provide some sort of funding for them to help offset their expenses. And then also potential termination or breach of procedures clauses that would maybe stipulate a certain amount of money that if a team, organization decided we're not coming for whatever reason, that they would then help pay for to offset some of those expenses. Some other aspects involved To consider in contracts would be maybe a lease agreements or damages. If a organization comes and damages a bunch of stuff, you might want to consider these kinds of things as well. And who's going to handle event personnel. All right. Well, hopefully this will help give you guys some thoughts and ideas to take a look at as you were working through contract law. This is just a brief overview of it all. Hope you guys have a great week, and make sure you take a close look at your chapter and read through the contract law section.